let's jump onto our first panel on freedom of expression and the digital speech ecosystem. We have three fantastic panelists for this discussion. Richard Moon is Professor Emeritus and formerly Distinguished University Professor at the University of Windsor. Jonathon Penney is an Associate Professor and York Research Chair in Artificial Intelligence, Data Governance, and the Law at Osgoode Hall Law School. And Suzie Dunn is an Assistant Professor of Law and the Interim Director of the Law and Technology Institute here at Dalhousie. So why don't we, no problem. So why don't we start with you, Richard? You've had a long and distinguished career as an expert on constitutional rights. Do you want to open with your thoughts on how the landscape has changed as a result of the popularization of social media and what that means for how we should understand freedom of expression?
Okay, I will try to do that in the very short time you've given us to start with. Can people hear me? Is that coming through? Okay. Anyway, let me just start with a little bit about how we understand freedom of expression and therefore, what these changes mean. So when we think about the commitment to freedom of expression, we think simply about the right of an individual to express him or herself and the right of others to hear what he or she may have to say. And we generally speak about we generally say that, well, the answer to bad speech or erroneous speech is more and better speech in some way. And this idea rests upon, involves not treating speech as a cause of harm. If a listener takes action in response to what they may hear, either because they agree or disagree with what's said, the idea is the listener is responsible for his or her actions and not the speaker. We don't treat speech as a cause in that sense. And underlying this idea, I think, are a couple of assumptions. And these are important to think about. One of the assumptions is that individuals... Oh, okay.
Sure.
Oh, I could speak louder, too, if I realized. Sorry. Okay. One of the assumptions is that individuals are substantially rational beings who are capable of assessing things they hear. Another is that we have before us, we are exposed to a wide range of different views, which we can hear, assess, make our own judgment about. There may actually be a third assumption, is that the state has the capacity to either prevent or punish harmful action that may follow from speech in different ways. But the idea then that people should be free to speak and that we should not treat speech as a cause then rests upon these two assumptions, that individuals are substantially rational and that they can have before them a range of different views or perspectives. Now, of course, we've always recognized that those conditions, those assumptions, don't always hold. And examples are given of the false yell of fire in the crowded theater, where individuals don't actually have the opportunity to stop, reflect, make a judgment of some kind about the merits of the claim there's a fire in the theater and so forth. So there's always been exceptions, if you like, recognizing that the conditions that underlie this commitment don't always hold. Oh, I don't know, is that even on? Okay, so you just forget everything I've already said then. Just ignore it. Is it on now?
Yes.
Okay. I can't tell from here how it's projecting, so I'm sorry about that. I do have the capacity to really speak loudly if necessary. I didn't realize that that would be needed. Well, in any event, I think in thinking about the change in the communication landscape, I think we really are confronting a situation where maybe these conditions, these assumptions that underlie our commitment to free speech aren't just failing in discrete situations, but may actually be presented with more systemic problems or a systemic collapse of these basic conditions. And I think that's the problem. Now, I don't have time to say a lot about that, but hopefully some of this will come out in our conversation. But I think what really, especially with the rise of social media, we're really witnessing is a situation where the harms of speech seem to be greater, and at the same time, our traditional legal responses to harmful speech seem to be increasingly inadequate to deal with it. And just a very simple example. I mean, when we relied principally on traditional media as the primary platform for public communication and so forth, well, despite all the failings and limitations of traditional media, they at least generally sought to filter out false claims. Well, that's no longer something we have, and we see disinformation as a huge problem, and not a problem that, in the past, of course, we had problems of deceit and so forth, but the law generally dealt with this in very limited and narrow ways. False advertising or defamation and so forth. Is that my limit?
No, not at all.
And now we see it as a far, far greater problem. And similarly with hate speech. Hate speech is with us, it's always been a problem, but now it spreads on larger and larger fragments of friendship groups, networks, and so forth. And law, in addressing it, is just too cumbersome, too slow. Criminal law, civil actions, human rights codes to address these. And so we really have to think creatively and very differently about how to address harmful speech as it becomes a greater problem, and law seems, as we've understood it, seems unable to address it. Okay, I'm sorry if I went on too long.
No, that's great. Well, let's go to Suzie next, because your work engages as well with, I think, both the best and the worst aspects of digital speech. I've known you as a passionate defender of freedom of expression, as well as your work in highlighting online harms. Can you talk a little bit about that tension as it's expressed in your work, as well as where you see the challenges governments face in regulating the internet?
Sure. Can you hear me on this mic? Okay, great. And I'm a very loud talker. I probably don't need the mic. But yeah, so my research looks at the really dark stuff on the internet. I find whenever I do a presentation, I always have to apologize about ruining people's day because I often don't have any good news. And in that, I fundamentally believe we need protections, right? When we look at the amount of sexual violence, the amount of hate speech, the amount of risk that we have to children, there is a need to regulate aspects of the internet. I'm a big believer that's an important piece of what we need to do in order to make these really fundamentally wonderful places. I think the internet can be a wonderful space when the parameters are put in place to allow for safe sharing of information and building of strong communities. But I think one of the challenges we have when it comes to regulating the internet and regulating digital spaces is that so often we look at these really dark things that are happening on the internet that need to be regulated, but that ends up being the primary focus. So when we think about kids, we're thinking like, oh, kids are being lured off the internet, they're being bullied off the internet, and you go with this very fear-based model. And that's often where a lot of media attention is around. When we look at youth suicides, when we look at some of these more extreme reactions people have to, being exploited or bullied online. And that ends up being the focus of when we're thinking about regulation. And often what we see in that is it leads more to abstinence-based models. So when we think about teenagers on social media, we say rather than requiring social media companies to be safe for young people, making spaces where they play games, where they connect with each other, where queer youth find community, rather than saying we're going to put the obligations on the companies that are creating these products to make them safer, we just say we're just going to not have children be on these spaces. We're going to say we're going to ban them 16 and under. There's a proposal here in Nova Scotia to have that happening. We're seeing that popularized elsewhere. And then other types of regulation are put in place, again, a bit of this fear-based model, but without actually thinking of the practicalities of how are these laws actually going to be enforced. So when we think of S209, which is regulating access to pornography, on whether you're an adult or a minor, and we regulate access to pornography in the real world. Like you've always had to get ID if you go into a sex shop or if you get pornography. Like I think it's appropriate for us to regulate some access to sexual content to young people, including in digital spaces. But then when we look at the practicality of how do we actually do that, what's the process of going forward to do that? Most of the ways that we can do that are wildly privacy invasive and have extreme risks to the information that's being gathered. And so I think governments are kind of number one, I think there are some people who are engaged in regulatory decision-making that don't have technological expertise, that don't actually understand how the internet works, how safety processes should be in place. And then their focus, again, is on this fear-based model rather than on a rights-based model and also on like a remedies-based model. I think this question of like, what are the remedies that people actually need and what do people want? You know, when we think about adding criminalization to things like non-consensual sexual deepfakes, I think there can be some benefit to that. But ultimately, you know, when people have really negative experiences online and are being defamed or having their intimate images spread because of the way the internet works, and it's so easy to spread quickly and across a lot of numbers, we need more swift remedies. You know, and so when we're talking to people and we're thinking about what are the laws that we need to be creating, we need to be protecting spaces so that people can be sexually expressive online, so young people can be safe in these digital spaces, and when they are seeking the support they need, that it happens more quickly. So we've seen examples of models like this in British Columbia. They have a civil resolution tribunal where if your intimate images have been released without consent, you can go through a fast track model rather than having to go through a full court procedure. And then the online harms bill was beneficial because there were some requirements about having timed requirements for some of the more sensitive content that's quite easy to identify and take down. And so I think when lawmakers are engaging in these processes, it's complex and it's messy. But I think often if you're not focusing on a rights-based model and a fear-based model, what you lean towards is abstinence and banning rather than regulation that actually creates the safe communities in digital spaces that we need.
So I think the point about these broader structural impacts of speech regulation, I think, takes us quite naturally to John. You're the author of an upcoming book on chilling effects. Can you introduce the relevance of surveillance or freedom of expression and what lessons you draw from your research?
Absolutely. So thanks for the introduction. It's great to be on this panel with such my distinguished colleagues here. Absolutely. So a lot of my research in recent years has focused on this concept of chilling effects. And the way I often think about it, the way I introduce it in you know, these kinds of discussions, and you've probably heard this concept before, and the way I talk about it in the book is, you know, the conventional view of chilling effects, especially amongst lawyers, especially amongst journalists and policymakers. We think about chilling effects this way. You have a law that's passed, usually by government, of course. It may be vague, it might be overreaching, and there's concerns that the law would have some kind of chilling effect because it maybe might capture certain behavior that we would consider free speech. A person sees a law, is worried that if they speak or act, they might face some kind of legal liability, and so they refuse to speak, they refuse to behave, refuse to act. They sort of self-censor themselves. That's what I call the conventional view of chilling effects and its concern. And this is in Canadian law. It's how Canadian judges often deal with it. It's the way American judges, pretty much throughout the West, in Commonwealth jurisdictions, common law jurisdictions, this is the way we think about this doctrine. When you get into the research, and I talk about this in the book, that's a very naive and narrow construction of the concerns about chilling effects. When you get into the real threats, right, the kinds of threats that have the most profound chilling effects on speech, on behavior, on every element of participation in democratic processes and democratic society and just day-to-day life, are other kinds of threats. One of them, an increasingly profound one, is surveillance today, especially forms of targeted surveillance. Another profound, and maybe the most profound, is the kinds of threats that Suzie's work deals with, and that is forms of targeted online harassment, forms of online abuse, and those kinds of threats. So in the book, I talk about how these other kinds of threats that have a chilling effect, privacy threats, targeted threats, forms of surveillance. Today, we are at an era where the bad actors are becoming increasingly sophisticated in understanding how they can weaponize what I call different chilling effect factors or tools and techniques in order to target certain communities for repression, but also change discourse within broader democratic society. And that's for using surveillance That's through using cyber mobbing and forms of large-scale abuse and targeted threats. That's through also targeted prosecutions and using laws that are overly broad, but not ones that regulate companies or regulate online platforms. We're talking laws that are then abused to go after political enemies. And of course, we look at the United States, we can see it. So some of the lessons that I take away from my research is that we need to stop thinking very narrowly about concerns about chilling effects. It's not just affecting certain groups or certain people. It's affecting all of our behavior every day, but in particular, certain communities that are already marginal within society are disproportionately affected. Visible minorities, sexual minorities, they're disproportionately targeted. You can see it in the discourse, and you can see it in the policy. And we need to be thinking more broadly, both about the threat, but also about our solutions.
So one of the common threads, I think, to all three of your comments relates to this emerging public-private distinction in speech regulation, or maybe that's better framed as the expansion of private sector speech regulation and its increasing relevance or dominance to our information space. That's true both in terms of the fact that private sector platforms are a vector for a lot of these harms that both of you have mentioned, that Suzie and John both mentioned, and then when we talk about the outdated nature of traditional speech regulation models going through courts, a lot of the newer methods that are out there are in the hand of private sector actors, whether it's adding friction to the spread of particular types of information or to virality or controlling amplification. I want to ask all three of you, what do you think is the appropriate response to the power of these platforms in a way that safeguards Canadians' right to freedom of expression, both in terms of the changing information dynamic that we face, and I think in terms of the sovereignty challenges, given their foreign ownership, which I think a lot of Canadians have woken up to over the past year. Maybe we'll start with Suzie, because you looked at me first.
All right, great. Cursive eye contact. I think it's interesting. I think when we think about regulating platforms, in a lot of the research that I've done talking to people who've been victimized online and who are chased out of some of these spaces, a lot of the things that are frustrating is that often the terms of service do capture some of the problematic behavior that's occurring, but it's the response systems that are really failing them. And that there's challenges with reporting particular types of harms that already are against the company's terms of service, and then either having the companies not respond at all, or when they do get a response, it's really complicated around how do you appeal it, how do you move forward with it if they say this doesn't actually meet the definitions of our terms of service. And so I think there's a resources and process piece with social media companies where they need to invest more time and money in that. And I think we might need to regulate companies in order to force them to do that. But there's also been really excellent models where you have things like trusted flaggers and external organizations that provide those types of supports. And here in Canada, we don't have a lot of those organizations. I was at a meeting with Google a few years ago and met with all of these people who work on these excellent helplines, cybercrime lines, support lines where they can go and get a variety of supports, emotional, technical, legal supports in order to help them navigate those issues. And so it's difficult because I want to advocate for those types of organizations. I think we should have them in Canada. We have a few. We've got CyberScan here in Nova Scotia. There's the Canadian for Child Protection in Manitoba, and then the BC helpline, but they're quite limited. They're often only dealing with sexual content. In Nova Scotia, it's broader. Not a lot of people are aware of them. But I think if platforms aren't going to be doing the work themselves, to manage the problematic content on their sites, having these secondary organizations can be really helpful. Often they'll have what's called a trusted flagger, and so you're an individual that works for Cyberscan or wherever else, C3P, and you actually do have direct contact with most of the large social media companies, and you can get a swifter response. And if people are saying, I reported this to the platform, they haven't taken it down, there's this secondary resource that's really important to them. And so in Canada, the 3 organizations that we do have, they're all statutorily mandated. And so I think governments, that's an option that they could have, is to have statutorily mandated organizations where people could get supports that would be in more direct communication with platforms, so people could get swifter responses when needed. Who's doing eye contact next?
The younger people have a better grasp of this than me. Oh, sure.
Yeah.
Right. So, what do I think is the appropriate response to the power of these platforms? So certainly today, and I think Michael's introduction and some of Richard's comments, I think, and of course Susie's contributions too. We understand how our day-to-day lives are mediated by these platforms, right? They've become essential to how we live, how we connect, how we communicate with friends and family. But increasingly, it's also how we do politics. It's how we also interact with our citizens in increasingly negative ways, right? And something that came up in conversation with some of my colleagues yesterday is this notion that I think is sort of salient, and we've heard people talk about and complain about notions of virtue signaling. I'm sure you heard this before. It seems like with these platforms today, there's a kind of vice signaling, right? That you can sort of signal through almost antisocial behavior, right? So who can be the most negative, attacking, critical, and divisive seems to be incentivized by these platforms and their algorithms, right? And increasingly we have the owners and operators of these platforms who care very little for the conversations that we're having today about responsibility and ethics. And so that, I think, is the era that we're living in. It's an era of surveillance capitalism, information capitalism, where the incentives for these systems, for these platforms to make money is to have algorithms, have content moderation, strategies and policies and programs that reward divisive, polarizing behavior, right? So that we're all increasingly angry at each other, we're increasingly hateful, we're increasingly engaged, but our attention remains on the platforms themselves. So how do you deal with the power of the platforms? I think it's got to be multifaceted, right? I think on the one hand, you need what the government of Canada has attempted to do a few different times, and what Europeans have done, and what Americans are not even having a conversation about doing, is that you need to impose certain responsibilities on these platforms. And that model has to be something that rebalances the power between the platforms and between us, the users, right? Where, for example, what was proposed in the online harms legislation, which was flawed, but I think the model idea behind it and similar models around the world are notions of like a duty of care or a due diligence responsibility or a duty of data loyalty, as some of my American colleagues often talk about, that's imposed on the platforms, where the platforms, if they're making money off of us, also have to be responsible to us, right? In the same way that doctors and lawyers and other professionals have a fiduciary obligation because they have certain expertise and power over their patients, right? These platforms have power of manipulation and deception over us, right? And it can't also be up to us simply. Of course, we all have to be responsible to behave better, to be better citizens in terms of scrutinizing and be better informed citizens about the platforms themselves and their policies and how they affect our behavior. But we also need regulators and governments to step in and take that burden off of individual users, right? It can't just be about consent. It can't just be about us reading Facebook privacy policies. It has to be more than that. So I think you need a few different layers. You need new strictly enforced obligations imposed on the platforms to be more responsible to us and to communities and democratic societies. They have to be enforced. We have to be more responsible as people and users and as families. But we also need broader structural reforms too, because of the obvious financial incentives for these platforms. So that means competition law reforms. We need structural reforms that reduce the incentive to make money this way. And that means maybe structural reforms that target the larger platforms and, quite frankly, penalties and punishments that are far larger, right? Because they simply don't care with these small penalties. It's got to be bigger. It's got to get their attention. And that's the only way I think it's going to be fixed.
Can I reframe it slightly for you, Richard? Insofar as
I'm already now.
oh, okay, well,
All right, yes.
well, just because because obviously one option is for the government to regulate the platforms.
Yeah.
Another option that we see very commonly is essentially for the government to deputize the platforms, to have them act as their own kind of frontline regulators. That's increasingly common global strategy. We've seen it here through either formal mandates or through informal mandates like job owning and other informal forms of pressure. And that raises its own, I think, really concerning constitutional questions because platform decision-making is typically outside of the scope of charter scrutiny. We have our own state action questions that go back a number of decades. So, I mean, I don't want to sideline you if you had your own a different response on this, but I would love to hear your thoughts about this evolving dynamic.
Okay. No, what I was this is on, okay. What I was going to say is I thought the advantage of, waiting and being third was that somebody else would say some of what I wanted to say and say it better. So thank you, Jonathan, around the question of the online harms bill, because I do think something like that is what we need in the duty of care imposed upon. But I think it's important to also think back and recognize that, of course, pre-internet, pre-social media, but pre-internet, most public discourse, most public conversation took place on privately owned platforms, which is to say newspapers, broadcast stations. Fortunately, we have the CBC, and as long as we don't have a conservative government, I guess we'll still have the CBC. But for the most part, on privately owned platforms of different kinds. Now, of course, their content and how their content was generated is quite different than, obviously, social media platforms. But there was an argument made, a constitutional argument made that was more successful in the United States, didn't really have a lot of life in Canada, but certainly had some life here. And that is that when government sought to regulate, and particularly to impose on newspapers an obligation to print or publish, the newspaper's argument was, well, we are speakers, and this is interfering with our free speech. And therefore, governments, you cannot play such a role. Now, of course, we're hearing social media platforms making that kind of argument primarily in the United States, but to some extent here. And I think the first and most important thing is that that argument be rejected and dismissed so that it is possible, in fact, to impose obligations of different kinds on social media platforms. So, I mean, that's a very, very basic thing, but it's a pretty important thing. Then I was going to say something similar, but less eloquent than Jonathon, about the importance of the online harms bill. And here is my most naive and unrealistic proposal, and that is that social media platforms not be able to collect data. I know it's their whole economic model and all of that, and instead let them charge subscription fees. And our world would be so much better as a consequence, and so much of the harm and damage that these platforms can do to public conversation, to the lives of individuals, would no longer be the case. And I know that's not going to happen, but I'm still going to say it. Okay, on the question of, I mean, something like the online harms bill, the proposal that you would have some government direction, oversight, the primary obligation would be on the platforms to design their algorithms so as to limit the harmful speech that may appear and remain, but was consultation with a government agency, it does raise questions about whether or not the charter then might become applicable to the different decisions and actions taken in furtherance of the policy by the platforms themselves. Because I don't want to get too much into law, but we know that under the charter, charter obligations apply to government actors or government action and not to private actors and private action. But that distinction, is often a very difficult one to draw, and our courts have said that when an otherwise private actor is carrying out in some way government policy or is implementing government programs, its decisions in implementing the policy or program will count as government action and be subject to the charter. So there's certainly an argument to be made that social media platforms could, in advancing government policy, be seen as engaging in government action. I think that's what you were getting at. I see.
Yes,
Yeah.
and the good news is I found my hypo for the midterm. Nobody from my common law classes in this is here, I don't think. So I want to go back to these some of these foundational ideas about freedom. I mean, you mentioned the state action doctrine. You said you don't want to go too deeply into the law, but we have 4 law professors here, and I think of probably a few people with at least a passing interest in law in the audience. A lot of our foundational understanding of the contours of freedom of expression dates back to cases from the 80s or early 90s. Keegstra, Zundel. Right. Do you have any thoughts about these standards and whether or how any of them need to be revisited as a result of how our speech ecosystem has changed?
Yeah, it's got to be Richard.
Well, I guess so. I guess I should have thought about this question in advance. So I'm going to think on my feet here, or on my seat, as it were. Yes. And in what ways? I mean, obviously, one way you've just introduced us to, and that is, who is the state, who is the government, who is not the state, who is not the government. So that's a whole issue. And really, I guess I return to my point about the ways in which traditional legal responses just are not adequate to address the harms of speech. And I guess to the prior point that the harms are greater, are different now online, and we need to think and recognize that. I mean, talking about harassment and so forth. Well, we used to think about that as something that was very much face-to-face, that occurred, when somebody in the workplace was confronted by somebody else in the workplace who engaged in a kind of persistent pattern of harassing behavior, or maybe out on the streets. But it was always very personal and face-to-face. And then you confront situations like, well, the Ward case. I won't get into the facts of it, but suddenly you've got things online, and they may not be directly communicated to a particular individual, but they're exposed to it in some way by the actions of others. And, we struggle trying to think, well, should we understand this as a form of harassment? Is it significant enough that, it should be the subject of regulation? So I guess I think all these standards were designed around, very particular model of speech that was often mediated, sometimes face-to-face, often mediated, but in a very, very different way. And this very quickly, and those who have a much greater grasp of new technologies can speak more intelligently about this, but I think about something like it's happened in the States, maybe it will happen here, the idea that a political actor who has a social media platform, that his or her account may then itself be seen as government action, subject to charter obligations. But it's very, and I'm not unsympathetic to that at all, but it's very clear that trying to apply the kind of standard framework of analysis under Section 2B, the freedom of expression right, say, is it expression? Okay, it's expression perhaps. And then how do we figure out what count as reasonable limits? that whole model is built around the idea of what we understand as very clear government action or legislation. How to determine what would count as a reasonable limit or a limit prescribed by law by a political figure who seeks to exclude some from access to his or her site. It just doesn't fit in any way. So I think that's just one example of many where our standard model of adjudication just doesn't map on very easily to the new technologies and their use of them. But anyway, I'll let those who are more knowledgeable about these things.
Sure. My research is more in the harassment side of things and the freedom of expression side of things, but I feel a little bit more comforted being in Canada. Often when I teach tech law courses, I have to remind my students that the freedom of expression in Canada and freedom of expression in the United States is very different, and a lot of the news and narratives that we get around freedom of expression come out of the United States, where I think in Canada we do have a better model for balancing the rights of people to express themselves and also protecting people from harm. So in some ways I'm comforted that we have the model that we do, but there's also really great scholars like Marianne Franks, who's an American scholar who's been challenging these ideas around freedom of expression in the American model and really thinking of like freedom of expression for who, like what do we want freedom of expression to look like? Is it our capacity to express ourselves freely and widely, or is freedom of expression like creating a world where a lot of people can express themselves safely? And so I think the way that we conceptualize it from a theoretical standpoint is really interesting. But I think when it comes to limiting speech, again, because the model is so different and the harms are so different, and so we've been speaking a bit, kind of a thread that's come through here, it's kind of the mobbing of people. So you'll have 1,000 individuals who will say one problematic thing, and if you look at that one person's comment, it doesn't add up to harassment, like it doesn't add up to hate speech, it doesn't add up to anything that could pass a legal threshold. But then when you look at the impact of those thousands of comments on one person, it crosses into something where it's so detrimental. A lot of people have to leave their homes, leave their communities because of this speech where you're able to gather and mob people together against an individual. But because our legal system is really focused on what is one person saying to one person, there's not a lot of legal solutions, which is where I think things like the online harms bill could be a bit more helpful for that. And then also looking at the instigation of speech. So there was a really interesting family law case in British Columbia where they were trying to define this concept of family violence. And it was two parents who were separated, and the child was a trans youth who was medically mature, was going through the proper medical systems in order to get gender-affirming care. And the father was very opposed to this and was very public in the media, was dead-naming their child, was publishing medical records with their children's information. And what this led to was extreme harassment towards the family and the child. And there was a question, was this father's behavior inappropriate, by creating turning his child into this poster child of hate so that all of these anti-trans people in British Columbia could target this young person who had mental health concerns, who had had attempts of suicide in the past. And at the court of the lower courts, I believe they found that it was to be family violence. And then the upper courts, they said that it wasn't because he hadn't really intended to cause the harm, right? And he wasn't really the person doing a lot of the harm. But he was the person who called on that harm. And I think it's a bit naive to suggest, particularly on a topic such as trans issues, which is one of the more difficult issues to have sensible conversations online, to suggest that he wouldn't know and that his child who reported to him about the experiences, the negative experiences they were having. So I think this mobbing thing and this way that there's a multitude of people and you can call on a multitude of people to cause harms, and how do we limit their expression when it's a collective expression rather than an individual expression? And I don't think our legal system is set up very well to address that.
Yeah, I mean, these are great. Points, and I guess I would just sort of quickly add, thinking about the older standards for freedom of expression and thinking about how the speech ecosystem has changed. I mean, even when we look back at how courts and lawyers reasoned about freedom of expression back then, lawyers have always had certain kinds of myths that we tell ourselves about how, the realities of speech and its effects, right? So the notion of the marketplace of ideas, right? The idea that, well, we should allow for like the freest conversation, the freest expression, and then the best ideas will rise to the top and the others will be discarded, right? That's always been a fiction. Even from the beginning that it was conceived, there have always been voices that are more privileged and other voices that have been more often subject to chill or repression or marginalization. But what I would say about the speech ecosystem today is that with these platforms, and even when the way we talk about these platforms, even the terminology, saying like platform, it suggests, right, a platform you stand up on like a stage and your voice is amplified, right? But even that sort of metaphor that we use for these service providers tells a bit of a myth, right, is deceptive about the scale and the scope of how speech and other kinds of harmful speech or lawful but awful speech, to use a term that Emily Laidlaw often uses in these contexts, which I think is a good one, about how speech is not just platformed, where you can stand on a stage or on a soapbox in an earlier era, where we all as citizens have our voices amplified and can reach. And that's a great thing for freedom of expression. But there's no doubt, as we now realize, that the operators of the platforms have their thumb on the scale with these algorithms. Elon Musk has an idea about what speech he wants to see on your feed, right? And he will adjust his algorithms accordingly to what speech and what content and what kind of interactions that he wants most people to see in most places. And it's not just his posts on Twitter with his millions and millions of followers, and he's tweeting like hundreds of times a day, right? That's just one powerful actor. But it's also your For You feed, right? If you look at who you're following, and then I switch over to my For You feed, it's a feed that's been designed for me. I feel so good about that. And it's people that I don't follow, who I wouldn't want to follow, and who I disagree with. But not just that. I mean, it's often filled with very divisive, polarizing, hateful, attacking content, right? So the marketplace of ideas was always a fiction. Today, it's like a fiction on steroids, right? And if that is the reality of our digital speech marketplace, or the place in which we exchange ideas, right, then inevitably the political discourse that we have in society is going to increasingly reflect. And our governance is going to increasingly reflect that. And we're going, therefore, in a pretty dark direction.
So I want to open it up to a broader Q&A with the audience in just a second. But I want to ask one more question. And I guess, John, you already sort of answered that for your side. But, where in our information space, just to bring this back to sort of the underlying Canadian democracy theme, where in the information space do you see our greatest vulnerabilities? And, I guess the flip side of that is, what are the ingredients that explain Canada's, I suppose, relative resilience to what we've seen elsewhere? And what are the areas of threat that we have?
I mean, I feel like I just...
Yeah. So I think you're off the hook, John, on that.
Sure. I'll jump in. I think, we got these questions beforehand, and I was reading over this one, and I struggled with it because I think that there are parts of Canada where we've been able to resist a bit of this authoritarianism, right? We look at the results of our last election, and in the influence of the Trump election, and and it gives me little bits of hope, but also Canada is also the birthplace of a lot of these problematic spaces, right? I think it's Proud Boys is Canadian, and there's a lot of the 764, that like nihilistic group. A lot of those guys are Canadian. Like the guy who ran the Deepfakes, Mr. Deepfakes website, he's Canadian. So I don't necessarily think that we have avoided it. So I think we have to be a bit careful about that Canadianism, where we think like we're okay, we're not racist, we're not sexist. Where like CBC, like one of the first the areas of stories they had to shut down stories on was Indigenous content, like even really positive Indigenous content. They couldn't allow comments on because there was just so much racism that showed up. So I don't think we have avoided it. I think we have a lot of work to do, and I think we need to stay consistently vigilant on it. I think that the more vulnerable spaces that we have are just the spaces in social media that really get us engaged in that like vitriolic excitement, where people almost love even like neighborhood apps, like Facebook neighborhood apps, and everyone's like, whose dog is pooping in the neighborhood, and everyone's getting like really tied up in that. And I think that there's an entertainment value in that, but also a really divisiveness and an element of hatefulness. So I think the way that internet drama and really kind of horrific things on the internet become our entertainment, like rather than watching TV, we're on TikTok or we're looking at a Facebook thread or we're looking at that. So I think like those are the most vulnerable spaces that we're in, and just getting people to step away and just like get outside and touch grass. I do a lot of interviews with young people, and some of them are struggling with like basic skill sets on how to make friends in the real world, and want to connect with people more in person, but the world just isn't really set up that way, especially those who went through the COVID generation. So I think finding ways to connect more in person and not have vitriol be our entertainment, I think is probably the thing that I'm most concerned about.
Yeah, I'm not sure we're immune in any way. More than 40% of Canadians polled willing to support a political party with a leader who mimics Donald Trump in many ways and offers no meaningful policies. And the only reason we got a Liberal minority government last time is because an awful lot of NDP voters were so frightened of Pierre Poilievre that they shifted their votes to the Liberal. Otherwise, the Conservatives would have had a massive majority, because 42% of the vote in Canada gives you that ordinarily. So much of this is fed by disinformation. So, disinformation is the biggest problem, and we really struggle with how to address it. It spreads very easily and freely online, and legal regulation is enormously difficult because it carries so many risks. Traditionally, free speech, we say in what seems increasingly naive model was that, we rely on more speech to correct error. John Stuart Mill's whole account is based on the idea that even if speech is false, nevertheless, it's really important that people hear different views and reach their own judgment, and they will only hold the truth in a very significant way and develop the capacity to know truth if they hear of various views. So I think disinformation is certainly the largest problem, and I think there are other sort of problems that go along with it. So one of them is our increasing inability to engage with one another. In fact, the growing belief that I shouldn't have to hear views that I don't like or I disagree with. When political views or views about a variety of issues form around, and I'll just put in quotation marks, friendship groups of different kinds, then one's political views seem to be a matter of group loyalty rather than anything else. And when people engage with others or hear the views of others, they seem to respond in much more of a combative way. They don't really have the ability to, or even the interest or willingness to engage in a meaningful way with the views of others. And so the breakdown of political conversation is enormous. It's a huge problem for a democracy. And then I guess I'll just add to it, as part of all that is the ways in which elements of our population have been encouraged and persuaded to not trust various sources of information. Free speech model is always built on the idea that somehow we all make our own judgments, but it's often not paid enough attention to the ways in which we have to make judgments about who to trust. I mean, I'm not in a position to make a meaningful assessment of data information about vaccine safety or about climate change. I have to rely on those who I believe have that ability and have that greater knowledge. And so the real question is, who do I trust? And historically, there are different experts, institutions, and so forth who we have trusted on the question. So I believe vaccines are generally safe. I believe they're generally effective. I believe that climate change is a serious problem because of whose judgments I trust in this. But any meaningful conversation breaks down when you have a growing element of the population who says, well, we can't trust them. These are these experts. You know, I'll make my own judgment, or whatever that means in this context. Anyway, so I think those are all various problems we confront in trying to carry on as a democracy in which we're going to have meaningful conversations about public issues.
Yeah, let me just sort of bookend that. I mean, these Richard and Susie's great comments, and just add, I guess, I mean, in ways, I think we have, you know, we often compare ourselves to the United States, and I think we've been more resilient to these challenges compared to the United States, but we're certainly not immune. I think part of it is that we've, as a population, have higher trust in more traditional institutions, including mainstream media institutions, higher trust in government. But over time, that's also eroding, right? So our trajectory is following where the Americans already are on this count. And I think part of where one of our main vulnerabilities, I think, is actually our complacency about our stability and about our resilience. I saw a news story the other day on CBC. I think I got like the notification on my phone and just quickly looked, and the way the reporting was, how has Canadian public opinion shifted so quickly from being generally very positive about immigration to being extremely negative about it, right? And in fact, if you look at polling about immigration over time, it's really relatively stable over long periods of time. But you see this radical shift in public opinion in recent times. What explains it? Of course, there are many factors, and it's really difficult and complicated to do a causal claim in this kind of context. But I think as people increasingly get their news and information from less mainstream traditional sources and instead get them from these online spaces, that's going to have increasingly larger impacts on public views and public opinion. And I think if you get your news from Facebook about immigration policies, if you get your news about immigration policies in Canada from X or Twitter or whatever you want to call it, the content on these platforms about immigration is overwhelmingly negative, right? Increasingly, it's xenophobic about immigrants and migrants. And it doesn't matter if you're based in the US, if you're based in Canada, you're going to see this content, right? And that over time is going to have an impact, even if you're a critical thinker, even if you view yourself as generally positive. I mean, if you're an American and you got your news solely from X, you would think that, and you just didn't consult other kinds of sources, you'd think Donald Trump probably won the 2020 election, not Joe Biden. Vaccines are largely unsafe, right? And, you know, Barack Obama was engaged in a large-scale surveillance operation to undermine the U.S. government when he was president, something like that, or then when he left office. I mean, that's what's out there, right? But then you look, Canada just lost its measles-free status, right? How did that happen? That's the increasing spread of false and misleading information about vaccines. And I'll just leave with one sort of last line, and this is, again, understanding the algorithms and how they impact. And a theory that's actually Adam Mockler, who's a Democratic young YouTuber, but also a Democratic commentator, and I think his theory is actually a clever one. He calls it the pipeline to volume theory of radicalization online. And that is, you know, he has friends, he describes, like, everyone is interested. He has friends who'll say, oh, look, I'm interested in working out. So you go on YouTube and you search for working out videos. And you you watch more, and eventually the algorithm recommends to you Andrew Tate and another far-right actor. And then once you're into that pipeline, it hits you with volume. The next algorithm is going to be Andrew Tate and others who watch Andrew Tate, like commentators and other far-right commenters. And then inevitably you end up down that rabbit hole, right? Somebody has problem dating, right? They're like, I want to go online so I can get some advice. And then you're hit with Jordan Peterson, and then people who watch Jordan Peterson, and next and next and next. And then you get hit with volume. And that's just the algorithms capturing your attention and monetizing it, right? But it leads you down rabbit holes, and these are just people who are looking for information, and they end up in an entirely different political space.
All right, let's open it up. If lots of questions. All right,
Yeah.
maybe to the middle to Toby. Yeah.
Thanks. A comment and then a kind of question for the panelists. And I mean, just on this issue of, what should we be worried about in Canada? I mean, personally, I think it would be wildly irresponsible for Canadians who believe in democracy and human rights to be complacent, and especially to be complacent based on looking south. Because first of all, the U.S. wasn't there 10, 20 years ago as first point. And secondly, I mean, that is not going to protect us. I want to just challenge a little bit Richard's philosophical construct around freedom of expression, which was sort of, the traditional idea that more speech is the best answer to bad speech. And of course, those views have been articulated by a lot of different commentators. But I would argue that that is far more an American value structure around free speech than the rest of the world. And I think if you look at the human rights protection of free speech and the way it's characterized, you will see that reflected. So the U.S. Constitution says Congress shall pass no law limiting free speech, and all of the other, basically all of the other guarantees don't work that way. The Canadian guarantee, of course, has a Section 1, which applies to all of the rights, but basically says, these are guaranteed, but subject to limit. And in international law, in the European Court of Human Rights, and most of the European and other, around the world guarantees, they, right within the guarantee of freedom of expression, they build in the section of limitations. So the idea there is, of course, if more speech is an effective antidote to the bad speech, then let it roll, because that's a less intrusive way of addressing the bad speech. But if it isn't, then we're going to regulate it subject to these conditions. So I think that, I mean, our philosophical attitude towards free speech is quite important for these questions that we're debating and all of these difficult new challenges that are coming up, I think, as all of you have made very clear. And so I think we should, understand that the, most of the world takes a view on a philosophical approach to free speech, that we should allow it as far as possible, but if it's harming us, we are going to limit it, and that's, of course, what we do. And actually, legally speaking, that's also what happens in the United States. It's not at all true that Congress doesn't make laws limiting free speech. They just have a weird constitutional interpretation that allows that. On the sort of how do we deal with this, and especially how are we going to get the deal with the platforms? I'd like to, and I think, Michael, you talked about, what about devolving responsibility to them? And I'd like to ask the panelists what they think about the European approach, specifically in the Digital Services Act, which came into force in November of 22. And it sort of has two main thrusts. First of all, upon receiving proper notice, actual notice of illegal content, they have to deal with that illegal content, take it down. But the second part of it, which is, from my point of view, much more important and significant for these kinds of issues, is that the very large online platforms, the VLOPs, need to, on an annual basis, undertake a due diligence assessment, risk assessment of the impact of their operations writ large, whether it's about legal or illegal content, whether it's sort of a lawful but awful, or this mobbing idea, and with a list of specific social interests that might be affected, including equality, children, elections, health, so on and so forth. And so they have to assess the impact of their operations, and then they have to put in place effective mitigating measures. All of that overseen by an independent system of regulation, which exists in each country, and also at the European level through the European Board. We're only in the first iteration of that. The regulators have been very hands-off vis-a-vis the first set of assessments, so they basically let the platforms, do their assessments and do their risk mitigation measures. My expectation, although I don't really have anything to base that on, is that they will ratchet up the kind of demand as things go on. It's the very first iteration. This is a radically new approach that's never been tried really anywhere else. So I wonder what you think about that for Canada. UNESCO has also issued guidelines for the governance of digital platforms, which essentially recommends a very similar approach. What I have observed in Canada, and I think there are some problems with this approach in Canada. First of all, we're a country of 40 million people. So pushing around the platforms in the way the Europeans do is a little more challenging for us. And we work globally, and we get questions from countries like Cambodia with 30 million people, what they're supposed to do, and they certainly can't push around the platforms the way the Europeans are doing. So I think that's a challenge. But also we have a very significant, federal division of powers challenge here. Europeans have a sole regulatory system and they can regulate all of these things. Freedom of speech, elections, equality, those are not falling within one jurisdiction here. If the feds, if there are 40 million people, are going to have trouble pushing around the platforms. Nova Scotia, with its 1 million, certainly can't do that. So I wonder what you think about the possibility of that kind of approach for Canada.
So I think maybe Richard, first on the question of the these dueling interpretations, and then if people have thoughts on the DSA.
Yeah, so you'll just have to trust me that I have what I believe is a much richer account of free speech in my writing, and in this, no, it's okay. But what I will say is, the word harm carries an awful lot, and harm is in many ways a conclusion as opposed to the starting point of analysis, and. What I think is that often when we're talking about speech being harmful, it's not just sort of looking at outcome, it's the nature of the engagement between speaker and audience. So when we talk about manipulation, for example, we're really talking about the quality and character of the engagement between the speaker and the audience. And so it has to do very much with the speech itself, the character of it. And I think that's also true of a lot of things we call harmful. So lifestyle advertising, or, when we're going to regulate advertising and so forth. Again, I think it's very much tied up with the nature of the engagement. And part of regulating hate speech, yes, it's about, do we want to take the risk that an extreme message will, land in some way with really, really concerning consequences. But it's also tied up with how we engage. And I think that the more speech plays to fears, anxieties, builds on stereotypes that that underlie our general public discourse, the greater the risk that some will take seriously the message and act accordingly. So I think when we talk about harm, we're also talking about the nature of engagement between speaker and audience often. So anyway, I don't want to get into my larger account of free speech here, but and I'm just, I think maybe that was my element of this.
On the DSA, I have thoughts, but I'll defer to the two of you first.
Go ahead. No, go ahead.
Okay. I do want to add one point to Richard's comments here. We often say, well, maybe the counter speech, like the answer is to these problematic speeches, more speech. But maybe the better point, and I think this is what Richard's getting at, is not more speech, but better speech, right? To the extent that we talk here, and there's obviously a demand side to some of this bad and divisive content, right? That is, there are clearly large numbers of people who feel that their views are not being reflected in discussion, political discussion within government, within mainstream political discussion and discourse, or the conversations that are being had. There's less tolerance for certain views. And I do think the point is taken that we have to be more tolerant about differing views, and we need more constructive political discussions, both from our leaders, but also within government and within our communities, right? And I think that's incumbent upon citizens, it's incumbent upon leaders, it's incumbent upon elites, being journalists or academics, to be a part of that, and promoting better speech as being part of that, while at the same time thinking about all these other challenges that we've been discussing. When it comes to the DSA, I think it has plenty flaws, but the Europeans have been the innovators in this space, right? No one else is trying what they're trying. The UK, I thought, after having their own incidents with problematic algorithms, a few tragic cases of a young girl who basically followed this pipeline down sort of self-harm content on, I believe it was Instagram and YouTube, and ended up committing suicide. And this was widely covered within the UK, and they're like, okay, we need to do something. And they came up with a white paper on a duty of care, but by the time it was enacted, it was really watered down, right? So my take on the DSA is that it has all the tools there to be effective to address many of the challenges that we're talking about, but it has enough discretion. It has to come down to whether the regulators are willing to be bold, right? And in enforcing these requirements, right? And some of that is going to be, well, let's give hands off, right? But they know that they're also going to face pushback, right? So they have to stick to their guns, and they have to impose and enforce penalties that's going to make these very well-resourced, powerful, wealthy platforms and the people who operate them, including, Elon Musk, who is just, has $1 trillion pay package, right? That's the guy that, in order to get his attention, a small couple $1 million fine that you take forever to enforce is not going to affect his behavior. And meanwhile, while you're doing that, he's going to be tweaking the algorithms and tweeting about the DSA enforcing it. And he's going to be targeting European spaces, and that's going to influence public opinion. So that's the challenge. The tools are there. Do they have the will? We'll see.
Yeah, we could probably actually just go to another question.
Sure.
Yeah, because
Thanks for this discussion. Also a comment and a question. One is, I think that we do a disservice to our ability to understand and regulate when we talk about the internet as needing regulation versus the companies and platforms that build on the internet, and that really has benefited the corporations and platforms that control, because the internet is a deregulated, interoperable infrastructure that was great before it got colonized by tech platforms. So I would just put that out there as something to consider. My question is around the constitutional rights of corporations in Canada, because in the US, corporations are people and money is speech, which has given rise to, in my opinion, a very imbalanced speech environment. And I guess my question is, to what extent does that hold here? And in the US, we have given the platforms speech rights as editors, but then also said you have exemptions from liability under Section 230, which we then exported through our trade agreements and are coercing other countries now through tariffs to also apply. So do you think that there should be completely alternate frameworks possible to regulate some of these platforms, such as common carriers or public utility type style legislation, kind of like my question to the previous speaker in the other session, because it feels like we're just not thinking that imaginatively, right? And we've decided that these companies get to have all these rights, all of these exemptions, but they play these core infrastructural roles in our information ecosystem. And particularly now as we talk about AI, which is going to be so personalized and also susceptible to all of that manipulation, but even less visibly, less clearly how, that is being kind of experienced by individuals. So I'd just love your guys' thoughts and information about the legal system here.
Mm-hmm. Do you know?
Well, the start.
No, go ahead, have at it.
Yeah, that's fine.
Thanks. Those are great points, and I'll come to your question. But I think the earlier point about thinking about sort of the internet, which was a different place with more organic forms of speech and engagement and sharing in communities, pre-social media, which in ways is an entirely constructed space. Mediated by algorithms and all of the things that we've talked about, the biases, both unintentional and intentional, and how these platforms are being operated. Internet regulation, but the platforms are separate, and we should be clear about that. Sorry, remind me your question.
Personhood for corporations.
Oh, yes.
Corporations, liability,
Yes. And this is a great point. And this is a point that, and I'll point to work. Shoshana Zuboff's work on surveillance capitalism, Julie Cohn's work on information capitalism, and I think in particular Julie's work is brilliant on this count, seeing how these powerful platforms have been able to influence law and weaponize law in their interests. This is something that's quite clear in the United States, like using First Amendment challenges to regulations. Saying, any kind of way that you might regulate what we're doing is a First Amendment violation, and they've been very good at promoting deregulatory agendas that way. But you see it also in Canada. Google's posture vis-a-vis the Competition Bureau is about we're a rights bearer, and you attempting to hold us to account under your regulatory regime is violating our rights, right? And of course, these platforms, these companies utilize all laws at their disposal in these contexts. I completely agree, too, with your point that we often fail in our imagination about having to deal with some of these challenges, right? I think one element of the challenge is to think about, yes, what we've talked about, the DSA and duty of care and duty of data loyalty, ways in which we can impose regulations on platforms. But what that assumes is the platforms continue to exist, continue to monetize, right? And that just seems like something that we've accepted. And Richard said, I have a dream that maybe we have platforms that don't collect data. But if you look at some of these different kinds of models, like a duty of data loyalty, which Neil Richards and Woodrow Hartzog have advocated to be adopted in the United States, good luck to them in getting that happening. But I can imagine being adopted in Canada and other jurisdictions where they say that kind of duty of data loyalty imposed on platforms might mean that, well, they'd still collect data, but tailored, personalized ads may no longer be legal under that kind of regime. But I think also, and I'm going to borrow a line from Ari Waldman, who's made this point in his book, Industry Unbound, that we need to also get comfortable with forms of prohibitions. We just say, we're just not having this being accessible in Canada, period, and there's no exceptions. We're not going to allow it and regulate it and let you guys do the delegated content moderation. I have two daughters, and I like to say that they're both young. I don't want them to have smartphones until they're 25. And I know that, again, that sounds like Richard's impossible dream. But I think we can also imagine a place where we have schools where, and I'm just looking at the research and the data that's out there, like Jonathon Haidt's work on the harms of social media. And I know there's contentions about the science and the evidence. But it's true, if you look at these powerful correlations where the rise in social media corresponds with almost perfectly tracked increase in adolescent depression and suicide, especially amongst young women, right? Now, how you can make a causal claim that correlations are correlations, we have to deal with that, but the reality is that I can imagine classrooms in schools with just a prohibition on these kinds of tools. Maybe our generation, we're done. We've accepted these tools as being part of our lives, but maybe we can do certain things for our children before they end up where we are.
Okay. Can I jump in with something?
Of
Because I just
course
want to
you
say,
can.
just because there's been a few, just to build on your previous comment about like imagining a world without surveillance advertising and where we have different economic models. I don't think it's actually that complicated to get there, and you don't even need to use a prohibitive approach. All you need to do is to tax data transactions. If you tax the harvesting, the wholesale, and the transfer of personal information based on the value that that information has, we keep hearing about data is the new oil, tax it the same way you tax people that are taking oil out of the ground. It's trivially easy to completely change the economic incentives that drive the digital economy. And you don't have to do it by having speech impacts directly. You don't have to do it by prohibiting editorial decisions on the way of the platforms. Tax them. Tax them to change their economic incentives, and the market will shift. Now, all of that comes down to, I think, the same problems that you mentioned related to the DSA, which is political will. And given the fact that our government just scrapped the digital services tax, it's not looking good as far as political will to move in that direction. But I do think that there are solutions there. They're underexplored, and it's not necessarily the obstacle to that is not because it's impossible, and it's not because of these constitutional challenges. It's 100% political.
Yeah, I was just going to say something very quickly about, corporations. Our courts have said that corporations have freedom of expression rights. But of course, whether one agrees with that or not, it's hard to draw the distinctions in any event. But we have limits on election spending, for example, significant limits on election spending. So it at least changes that dynamic and the potential influence. I suppose the real relevant question, it was something I talked about earlier and Jonathon was talking about, is whether when we understand a corporation to be speaking or to be a speaker of some kind. And that's the whole question about, well, is our algorithm and how we structured things, that counts as our speech, and therefore there should be no government action that seeks to interfere with that. And I think, as I said earlier, that's exactly what needs to be rejected so that there is, in fact, space to oversee some of those actions. But anyway.
Yeah, and I think one of the pieces that you're getting at too is this inevitableness, right? When we're thinking about these corporations, I think there's such a permissiveness about them, and then that fearfulness that we have about the comment you were making earlier about us being Canada and us being little, and we have seen that, right? When we looked at the Online News Act, and they said, well, it's just no news. But I do think, yeah, and I think that is a risk for us here in Canada. But I think again we have to push back against that and really be considering these things. It's why would it be that these companies get all these benefits without having any of the consequences and responsibilities? And I think that there is a political will thing because we are so engaged with these services, and the idea of having them be pulled away from us or taken away from us or altered in other ways, can be unpopular in the general population, except for when you're talking about kids. I feel like they're ready to regulate on kids, but for adults, there's that pushback. But I think we do have to challenge that power feeling where right now there is really embedded in our culture that inevitableness that I think makes it difficult both for individuals and governments to take action.
So, Michael, I think this is a great suggestion, and I agree. It comes down to political will, right? And part of this is the complacency that we talked about earlier. I think the other part of this is that it's really hard to do any kind of legislative action in this space, because as soon as you try to do something that addresses these kinds of challenges, it's immediately framed by political opponents, but also by irresponsible, mainstream political journalists and commentators as a form of censorship, right? That it's about repressing disfavored speech and privileging other speech. And so if that becomes the frame, then it's really, really hard, and I can understand why politicians are reticent to try to be robust in this space. And I think that's incumbent upon, experts and academics to be a part of that conversation, to try to help contribute to a better informed public conversation about these proposals. I think it's incumbent upon politicians and journalists who report on it to be more responsible about it. But that's inevitably one of the challenges that we face in this space.
I mean, we could add quickly, too, a different administration in the United States would change things, and not a president who was advocating for the various tech companies, so that, because that's really what happened with the backing down from the digital service tax. Yeah, the threats.
There's a lot more to say, but I don't want to keep folks from lunch. So please join us in thanking our panelists.